So now, Robert, if you want, you can introduce yourself, please. And we take it from there.
Hello, everybody. My name is Robert Angyal, and I'm joining the symposium from Sydney, Australia. My name is spelled A-N-G-Y-L, A-N-G-Y-A-L, in case you want to Google me. It's Hungarian for angel. And my father anglicized the pronunciation, but unfortunately not the spelling. But I'm stuck with it. I'm a barrister, namely a trial lawyer and mediator based in Sydney, Australia. I've been mediating since 1991. And Vikram has asked me to give you a brief snapshot of the development of mediation in Australia and the current state of play about mediation and issues arising in relation to mediation in Australia. I can probably do this best by recounting my personal experience, because my personal experience pretty much covers the development of mediation in Australia. I actually returned to Australia in 1985 after 10 years living and working in the United States and practicing law there. And I joined a large law firm in Sydney in the litigation department and started talking about mediation to the partners of the firm and promoting mediation, because I'd learned a bit about it in the United States. I very quickly found out that they considered me both mad and dangerous. They considered me mad because they asked rhetorically, why would a partner in this law firm suggest to one of his clients, they were all male, that the client negotiate in a dispute and thereby suggest that he was in a weaker position? And why would a client ever do that to put himself in that position, because they were all men, with respect to a client? And why would why would he suggest that a client put himself, they were all men, in that position vis-a-vis his adversary? That was the mad bit. The dangerous bit was, well, they said, if your crazy idea took hold and we mediated everything, what would happen to all the fees that we make by running litigation in the court? And with the exception of a couple of partners who had some more vision forwards, that was pretty much the reaction that suggestions of mediations in 1985 engendered. It also, you very quickly got the impression that real men didn't mediate, real men litigated. And suggesting that you were prepared to negotiate was going to be taken as an admission of weakness. We of course know that's crazy. And what makes me feel justified is that after I left the firm, not having been very successful in promoting mediation, they got religion, and there was a whole series of cases resulting from the drop in value of the Australian dollar against foreign currencies. Many Australians have taken out loans in foreign currencies. And when the Australian dollar greatly dropped in value, those loans became vastly more expensive to repay. And a lot of people sued their banks. My former firm acted for a large Australian bank, and they were very proud to say that they mediated all the foreign currency claims against the bank except one or two, and mediated them successfully. So that was long after I'd left. So after I went to the firm, I went to the bar, which means I became a barrister. We're the people who wear the wigs and gowns in the English tradition. And I started promoting mediation at the bar and also among solicitors. And I was responsible for the Law Society, which is the body of solicitors in New South Wales, setting up the first ADR committee in Australia in 1995. I had to write a memo to the councillors of the Law Society explaining to them what ADR was. And one of the signal achievements of that committee was to set up the first settlement week in Australia, which took place in 1991. In settlement week, we mediated 250 personal injury cases in the New South Wales Supreme Court, the highest court in New South Wales. At that point, there was a large quantity of personal injury cases clogging up the court's lists. The court sent out 10,000 letters to parties in those proceedings seeking cases where both parties agreed for their case to go to mediation. And we ended up with about 250 cases, which were mediated in a week, which we called Settlement Week in 1991. It took about 5 years to organize this, but it was a big success. Interestingly, when we looked around for people who could mediate these disputes, we only managed to find, I think, 32 people in the whole state of New South Wales who were arguably qualified to mediate. I was one of them. Many of us had learned about mediation, but hadn't had the opportunity to actually do it. And many of us, like myself, had the first experience of mediation in Settlement Week. And it was very successful. The second year we did it, 1992, I think we found 67 people in New South Wales who regarded themselves as qualified to mediate. These days, if you stood in the legal precincts of Sydney and put up your hand and said, I'm looking for a mediator, you'd probably be bowled over in the rush, because there are lots of people out there wanting to mediate and a lot of people out there mediating. It's now a very competitive profession in New South Wales. I went to the bar in 1989, meaning I became a barrister, and I continued to promote mediation. I was behind the Bar Association, which is the Barristers Association, forming its own mediation committee, and I served on that for a very long time. At the time, and I still think it took some courage to identify yourself as someone who was interested in mediation, because there were people at the bar who took that position that you didn't know how to fight a case hard in court, that you didn't know how to cross-examine, that you weren't a real litigator, because real litigators don't mediate. But we all know that that's nonsense, that all good litigators are constantly thinking about how to settle, because litigation is always uncertain. And all good mediators are always thinking in the back of their mind about what would happen if the case went to court. So the two basically inform each other in a very circular and continuous way. But at the time, there were those at the bar who thought anyone who promoted mediation was either a long-haired radical or was someone who couldn't cross-examine effectively and was looking for a way out of doing that. Both of those are nonsense. I'm not a long-haired radical and I can cross-examine effectively. That doesn't mean I can't be a good mediator. In terms of developments of mediation in Australia, there were two big ones in the early 90s, apart from settlement weeks. And the first was that legislatures began to realize that mediation was a good way of solving the problem of the courts being overburdened. And the court started making mediation mandatory over some protests from people who thought that mediation couldn't be mandatory because it was voluntary. I'll come back to that. And now the situation in New South Wales is that all courts have the power to refer any proceedings at any stage to mediation, whether or not the parties consent. And they do that. I've been involved in at least one case which was ordered to mediation 3 times before it settled. And the basic rule in New South Wales is that all civil matters are mediated before they go to trial, if they go to trial. If they settle, of course, they don't go to trial. So mediation is no longer alternative dispute resolution in New South Wales. It's really primary dispute resolution. The only cases that go to trial are the ones that didn't settle at mediation. So to call mediation alternative dispute resolution is now a bit misleading. It's really mainstream or primary dispute resolution. That was a big advance. The other big advance was a case decided in the New South Wales Supreme Court in 1992 called Hooper-Bailey, Hooper-Baillie, by a judge called His Honour Justice Giles, Giles. Hooper-Bailey concerned an agreement to mediate and the question of whether it was enforceable if one party didn't want to comply with its agreement to mediate. And it's a remarkable decision that I've written about several times because both parties solemnly assured the judge that there was no relevant authority. There were, which was wrong. There was authority in the English courts to the contrary. And the judge went away and considered the arguments, considered the authorities, and came up with a decision which has 2 genuine intellectual breakthroughs in it, which is why I say it's a big advance. The first breakthrough was this. The English courts and some earlier Australian decisions tended to view an agreement to mediate as an agreement to agree, which, as you know, is not enforceable as a matter of contract law, or even worse, they tended to regard an agreement to mediate as an agreement to attempt to agree, which is even less enforceable. And the judge said, and this is the first intellectual breakthrough, that properly understood, an agreement to mediate is not an agreement to agree or an agreement to attempt to agree. It's an agreement to enter into a process, which we call mediation, whose terms can be outlined quite clearly. And it's a process from which agreement may come. It may not come, but it may come. But whether or not agreement comes from it is beside the point. The parties have agreed to enter into that process we call mediation. And why, as a matter of law, shouldn't they be held to their promise to do that? That was the first intellectual breakthrough. And I'll come back to why that's important. The second intellectual breakthrough was that if the terms of the agreement and the terms of the process called mediation was sufficiently clearly defined, there was no reason why the courts couldn't enforce that promise, either be by refusing to let one party commence proceedings until there'd been a mediation, or even more directly, by granting a decree of specific performance of the agreement to mediate. Namely, the court would order the unwilling party to honour his or her or its promise and engage in a mediation. The reason it's a big intellectual breakthrough is that the English courts at that point, and still I think, had a very primitive view of mediation. They regarded it, as I've already said, as an agreement to agree. They also said, well, you can't force people to engage in mediation because it's a voluntary process. And that really confuses the issue profoundly. It's true that a mediation won't result in an agreement unless there's an agreement. That's obvious as a matter of, that's clearly and obviously true. That's self-obviously true. But that doesn't mean that whether people enter into the process that might lead to an agreement is a voluntary matter. People used to think that voluntary mediation was an oxymoron, a contradiction in terms, but of course it's not. People that can agree to mediate and then not honour their agreement, and they can be forced to honour their agreement and enter into a mediation. There's no contradiction there, and it may or may not lead to an agreement. My personal view is that no mediation is voluntary. People only mediate because they think it's likely to lead to a better result than not mediating, but it's not voluntary in a real sense. People don't mediate because it's fun. It's not something you do on a Sunday if you had a choice of other things to do. It's stressful and expensive and time consuming and exhausting, and you wouldn't do it unless you really thought you had to. So the whole voluntary, non-voluntary mediation distinction, I think, is a distinction without a difference. But Hooper Bailey took the English authorities on headlong and said, well, we're not following those in Australia. We're going to hold that an agreement to mediate is binding if properly drafted, which put a lot of heat on us as practitioners to make sure our mediation agreements, our agreements to mediate, were carefully and properly drafted. So that, plus the thrust of legislature in Australia in making mediation mandatory, took us a long way towards making mediation respectable in Australia. The other thing that made mediation respectable, particularly in New South Wales, was that a particular Chief Justice, a man called Sir Lawrence Street, retired as Chief Justice and promptly set up as a mediator. And his doing that gave mediation instant respectability in New South Wales because he was a highly respected former Chief Justice. He was also, as it turned out, a very good mediator. He spoke, as well as mediating, he spoke and wrote quite widely about mediation. His speakings and writings were very persuasive and influential. I remember Sir Lawrence saying to an audience of eager listeners that a good mediation settlement was one about which the parties were equally unhappy. And everyone pricked up their ears and said, what do you mean unhappy? We've all read Getting to Yes, and we all know that we're meant to find a win-win solution and walk off after the mediation down the primrose path into a rosy sunset, happy as Larry. But the truth is and Sir Lawrence was right about this, that in most mediations, you have a zero-sum game, you have a pot of money of a certain amount, and if the plaintiff gets $1 more, the defendant gets $1 less. So the typical mediation, not the only sort of mediation result, but the typical sort of mediation result is one in which, as Sir Lawrence said, the parties are equally unhappy, which means both parties have had to compromise away from their ideal position, and both parties have probably compromised more than they wanted to, hence unhappy, and both parties have probably compromised about the same amount, hence equally unhappy. And that is a workable definition of a fair mediation settlement, in my view. And Sir Lawrence was dead right about that. So let's come back to myself and my practice. I'm what's called a senior counsel, which means I'm a senior barrister at the New South Wales Bar. My practice is partly the traditional practice of a barrister, namely giving legal advice, helping settle court documents and other documents used in court, such as affidavits, sworn statements. And it also involves, of course, going to court, running cases, and that's the traditional part of my practice. The other part of my practice is as a mediator and as a barrister representing clients in mediation. I do both of those, and I enjoy all the aspects of my practice. There are a few people in New South Wales who now exclusively practice as mediators. I've often been asked if I want to do that or if I am doing that. But frankly, I enjoy all parts of my practice equally, and I think they all inform each other, because I think good mediators always think about what would happen if the case went to court, because that tends to define the outside parameters of any possible settlement. And all good litigators, as I've already said, always constantly think about how a matter can be settled, because settlement brings certainty, settlement avoids risk, settlement saves costs, settlement can often save an awful lot of personal strain and anxiety, and settlement brings certainty. So good litigators, I think, always think about settlement. But that's also a big change. When I first went to the bar in 1989 in Sydney, we were each required to have what was called a pupil master, a senior barrister who supervised us for the first year. And my supervising barrister, my pupil master, said to me one day, he said, "You know, Robert, if you have a brief to appear in a case, that means, in the traditional terms, that you're not allowed to talk about settlement of the case, because your only instructions are to appear in court and litigate the matter hard." And that greatly surprised me, because I've always regarded litigation and settlement as going hand in hand. And I think that would now be regarded as a very old-fashioned view. But at the time, he said there are still barristers in New South Wales who believe it's unethical when you hold a brief to appear to discuss settlement with your opponent, even if your opponent wants to discuss settlement with you. That view, I think, is long gone. And we now, in fact, have a professional obligation in New South Wales to bring to our clients' attention the fact that there is a thing called mediation, and that there is an alternative to litigation presented by mediation. So as I said a little while ago, mediation is very well accepted in New South Wales. It's ubiquitous. It's in that almost every civil case is mediated at least once before it goes to trial. And that, of course, means that for barristers, trial lawyers like me, knowing how to represent clients at mediation has become very important as a skill set, because the only cases that are going to go to trial are the ones that didn't settle at mediation. So if you get a brief to appear, you have a 100% chance of representing your client at a mediation. We all know that a high percentage of cases that go to mediation settle, and that means, of course, you have a much lower percentage chance of actually ever representing your client in court, which you would think to a rational person would mean that learning how to represent a client at mediation is actually more important than learning how to represent a client in court. But try telling that to the upper echelon of the Barristers Association in New South Wales, which is very, very traditional. But eventually, I think that realization will come home to roost. My interests, apart from being a practicing lawyer, also involve quite a lot of writing and teaching about mediation. And one of the areas I've explored in both my speaking engagements and my writings are the ethical obligations of lawyers when they represent clients at mediation. We pay quite a lot of attention to the ethical obligations of lawyers in court, but there's very little written or taught to new barristers about ethical obligations how they represent clients at mediation. And you can immediately see, when you think about it for a few minutes, there are ethical pitfalls in representing a client at mediation because it's a negotiation. It may be a tough, hard-fought negotiation, and the temptation to embellish, exaggerate, even deceive about what your client's bottom line is, for example, are very great. But all those things are prohibited by the ethical options of barristers representing clients in mediation. I'm a co-author of a very recent article which has just been published in the United States called Legal Lying, with question mark, comparing the ethical obligations of Australian lawyers appearing at mediation with the ethical obligations of American lawyers. And astonishingly, my co-author, who's also an Australian, and I found out, the model rule published by the American Bar Association relating to representing clients in negotiations in the United States actually permits US lawyers to lie when they're engaging in negotiations. They're allowed to tell untruths as long as they're not material fact. But try and get a dish of what it means, and you end up in a legal quagmire. And ironically, we point out the American Bar Association has issued a 22 paragraph defining when US lawyers are allowed to lie when negotiating. The irony of issuing an ethics opinion about when lawyers are allowed to lie seems to be lost on in the United States. We've done a careful comparison of US and Australian obligations of lawyers representing clients in mediation. You can find that in the Pepperdine Dispute Resolution Law Journal, Volume 21, Number 2. And I'll ask Vikram to put up an article when we finish this video. I've also done a lot of thinking and some writing about the whole concept of mediation, why it works and how it works, and about the concept called party self-determination, which is regarded by many people who write about mediation, particularly academics, as being a terribly important concept. The concept of party self-determination is said to be a central concept in mediation theory, namely the notion that in mediation it's the parties themselves who determine the outcome, if there is to be one, of their interaction, their negotiation, their mediation, as distinct from a situation where you're in court or an arbitration where a third party imposes a result on the parties. Party self-determination is a much written about concept, and I thought this is a really important thing. I should work out what this is all about. But as I read about it, I discovered to my astonishment that some of the basic questions about party self-determination had never really been discussed or answered. For example, we know that party self-determination means, as I've already said, that the parties to a mediation are the ones who decide how, when, if, on what terms it's going to be settled, as distinct from the situation in a court or an arbitration where a third person is a result on the parties. It means that's really self-evident, and my point was calling it party self-determination doesn't really add much to the concept I've already explained, namely that it's the parties themselves who decide how, when, and what terms the dispute is going to be resolved. So then I asked, well, does party self-determination also the way that parties for mediation relate to each other? And that seems to be a question that nobody had really thought about. But it's an obvious question, because the whole phrase party self-determination seems to imply that each party to a mediation could himself or herself or itself determine the outcome. But of course, we all know that's not true, because it's a negotiation and there won't be a result unless the parties find a way to agree with each other that there will be a result. Otherwise, they just go home unhappy with the dispute unsettled. So I asked, well, does party self-determination say anything about the way the parties should behave towards each other? And once you start asking that question, you get lots of strange answers saying, oh, yes, they've got to be nice to each other. They've got to collaborate. They've got to have each other's in mind. They've got to have a holistic, mutual relationship. And they've got to end up with a result that is fair to both parties. Otherwise, the parties don't both achieve self-determination. At that point, things started going off the rails as far as I was concerned. Alarm bells started ringing, because I said, well, hang on, now you started talking about defining self-determination and whether in terms of whether the outcome is fair. You've shifted the emphasis from the process by which an agreement is reached, namely the mutual agreement of the parties, to the content of the agreement. And if the parties don't achieve self-determination unless the result is fair, who's going to determine what's fair? That means there are some external criteria out there that somebody has imposed, and unless the parties' agreement satisfies those criteria, you're saying parties have self-determination. That means that self-determination is something completely different. You're defining it as an agreement that satisfies some external criteria, which are undefined, and it's not clear who's imposed them and by what authority, rather than an agreement reached by the parties themselves rather than imposed on them. And once one goes down that track, the whole concept of party self-determination falls apart. We get into all sorts of debates about whether mediated agreements have to be fair. If they have to be fair, who's going to determine how they're fair and by what criteria? And how's anyone going to know anyway? Because nobody's privy to most mediation agreements, but the parties, because mediation is conducted in confidence, and often the settlement agreement is confidential. But once one opens that door and starts talking about fairness, then you find lots of writings in the academic writings about power imbalances between the parties and the ethical obligations of mediators to level up power imbalances to try and make sure the outcome is substantively fair, not just fair in terms of process, in terms of having equal time and equal opportunity to be heard, in terms of substantive fairness of the agreement. And at that point, I think the whole thing goes off the rails, because most writings about mediation are by academics who haven't done mediations. And it hasn't occurred to any of these writers, it seems to me, that when you start talking about power imbalancing, when you start talking about mediators balancing up power imbalances between the parties, nobody's really thought about how that's going to happen. So I published an article about this in the Newcastle Law Review, which is a local Australian law review. It's online and available to everyone. It's called "Is Party Self-Determination a Concept Without Content?" And again, I'll ask Vikram to put up a link to the article when we finish the symposium. But the real practical problem I point out in the article about mediators balancing up power imbalances is this. Let's say I'm having a preliminary conference with my parties to a mediation, and I'm explaining to them how I'm going to run the mediation. And in the preliminary conference, I say to the parties, I say, well, of course, part of my job as mediator is this. If I detect a power imbalance between the parties, it's my job to try and level up the power imbalance to make sure the parties are equally powerful in their negotiations with each other. one of the parties is going to say, well, hang on, that's not right. I've just spent a lot of money on legal fees and a lot of my own time in getting ready for this mediation. We've done a lot of research. We've into the facts and the law. We've very thoroughly canvassed the other party's position. We prepared internal position papers. We've contemplated lots of different possible options to resolve that. We've come up with a comprehensive negotiating strategy, and we've done all of that to increase our bargaining power at the mediation. And you're telling me, and the party said, and we have to know that the other party is skimping on preparations. They're just spending very little on preparations. They're going to turn up and just see what happens and play it by ear and ad lib, hope things go their way on the day. So we spent a lot of money on getting ready and increasing our negotiating power. They've deliberately decided not to spend much money, and because of that, they're not going to be in a good position as far as negotiating power goes. And you're telling me that I'm going to be paying half your fees to undo all my good work and try and put the other party in a decision of me. That party's going to say, look, thanks, you're a nice guy, but we're going to go look for a mediator who's not going to interfere with our preparations and our negotiating power. Nice meeting you and goodbye. So a mediator who honors the parties about or her intention to negotiate power imbalances is just not going to get the job. They're not going to be hired. They're going to be passed over for a mediator who's not going to do that. And that makes, in my view, academic. All the talk in the publications about mediators balancing up power imbalances. Mediators who are frank about what they're going to do aren't going to get the job. If the mediator is not frank about what they're going to do, they're also in difficulty, because almost all mediation agreements require mediators to be neutral and impartial. And anybody who thinks about it for a moment can see that a mediator who spends time and energy trying to level up power imbalances is not being neutral and impartial. And therefore, he or she will be in breach of the mediation agreement. And almost certainly in Australia, in breach of an important law called Australian Consumer Law, which requires you to not to make representations that are untrue. And again, if you let me know that as a mediator you're neutral and impartial, but in fact you intend not to do that and to level power imbalances, you're going to breach that law and render yourself liable for damages to the unhappy party. So all of this is covered in great detail in my article about party self-determination, because one of the core parts of the concept is that, as I said, agreement should be substantively fair, and that mediators have an ethical obligation to level up power imbalances in order to produce results that are substantively fair. I also say in the article that this concept doesn't work because nobody can know what a substantively fair result to a mediation is. How can a mediator know whether a particular proposed agreement of the parties is substantively fair? There's no point asking the parties, because they would disagree. If they could agree on what's a substantively fair outcome, they wouldn't need a mediator and they wouldn't need a mediation. They would just sign on the dotted line. So there's no point asking the parties. How else could the mediator know what's substantively fair? Well, I suppose the mediator could think about the likely outcome of the court case that might follow, or the arbitration that might follow, if the mediation weren't held. But that doesn't work either, because there's a wide range of possible outcomes to any piece of litigation, as lawyers know, or to any particular arbitration. It's all going to depend on a lot of factors, some of which may not be known to the mediator. And besides, mediations are often resolved on bases that no court could order, and that's one of the strengths of mediation. So if a mediation is resolved on that basis, as is often happen, you can't compare it with the outcome of the hypothetical court case or arbitration, because no court could reach the result that the mediation reached by agreement. So one of my other points in the article is the whole concept of substantively fair outcomes is an illusion. It's easy to say, but it's impossible to actually put into practice. And there's a very practical reason again for that. Mediations are conducted in private. The settlement agreements are usually private. who's going to know what the agreement is, let alone whether it's definitively fair? So for all these reasons, my party self-determination article ends up with the conclusion that party self-determination actually is a concept that is not very useful, and we should abandon it and get on to more important things. Some of the more important things I suggest we should think about are: why does mediation work? How does it work? Why is mediation such a powerful way of producing an agreement between parties who are in profound disagreement with each other? And my article deals with that also. There are two central mechanisms, I think, that make mediation work. And it's surprising to me that how little discussion there's been about them in the academic literature. Most academic literature about mediation is written by academics who don't mediate. They have that disadvantage of not having practical experience. They also are bound by the academic rules that they can only put things in their articles that other people have written about mediation. But most of those other things are written by academics who also don't have any experience in mediation. So most writings about mediation are by people who don't have any experience in mediation, and they're relying on other pieces published by other people who don't have any experience in mediation. That's why, in my, a lot of academic writing about mediation is interesting but academic. So here's my go at the two central mechanisms that make mediation work. The first is risk and the desire to avoid risk. All litigation is risky because the result is uncertain. Every court case's result is uncertain. If the result were certain, there wouldn't be a court case. If the parties knew what was going to happen, they wouldn't go to court. They're going to court because they are in dispute as to what the result is going to be. Cases where there's no real dispute tend to settle. Either the plaintiff gives up or the defendant gives up. But so by definition, the cases that go to court and cases that go to mediation are ones in which the result is uncertain. Both parties know they are at risk of a result that they're going to be very unhappy. They may end up with a result they're very happy with if they win, but they may end up with a result they're very unhappy with, and they want to find a way to avoid the risk of that happening. In Australia, where we had the English cost rule, which means, in simple terms, that the loser in the court case always is ordered to pay the winning party's costs. That means if you're the successful party, the losing party will more or less pay your costs. But it means if you're the unsuccessful party, you'll end up paying not only your legal costs, but also the legal costs of the winning party. And that can be crippling because court costs, as we all know, tend to be very large. It costs a lot of money to get good lawyers working hard to get it right. There's no avoiding that. So anyone facing a piece of litigation knows that they are at risk not only of losing, but also of paying not only their costs, but the other party's costs. And they may well be looking for a way, they usually are looking for a way to mitigate that risk. That's the pressure, that is the power that drives people, in my view, to mediate and drives people towards settlement in mediation. That's the first and central mechanism. One of the things I've explored in the self-determination article are things that I call cost traps. Let me explain what a cost trap is. This won't apply to jurisdictions which don't have the English cost rule, but it's very important in jurisdictions like Australia and England, which do have the cost rule. If you're a plaintiff and you're partly through a piece of litigation and you're heading towards a trial, you may be in the situation where you run out of money and you can't afford to run the case to trial because the barristers, the solicitors will want to know up front that you're capable of paying their fees. So you can't afford to run the litigation. But the rule is if you discontinue your litigation, you'll have to pay not only your costs, but the defendant's costs, because to be fair to the defendant, you have to undo the costs you forced the defendant to incur by running this piece of litigation that you're now bailing out of. So the cost of discontinuing is that you pay the other party's costs, but you may not afford to pay them either. So you're caught in a cost trap. You can't go forward by continuing the case to trial, and you can't stop because that would involve paying the other party's costs. You are caught in a cost trap. And one of the reasons, in my view, is parties go to mediation is that the plaintiff is caught in a cost trap and is looking for a way out of the cost trap. The cost trap can also affect defendants too, because it costs money to defend yourself in a piece of litigation. But there are lots of cases where you know, even if you win and get a cost order against the plaintiff won't be able to afford to pay your costs. So you're caught in a situation where you have to defend yourself and expend legal costs, otherwise judgment will be entered against you. But you know, if you successfully defend the case and win, it'll end up in quite a lot of money because the plaintiff, even though ordered to pay your costs, won't be able to afford to pay them. So that is also a cost factor for defendants. What it means in practice is this: if you're a defendant and you know it'll cost you, say, $100,000 to defend yourself in a piece of litigation, but that the plaintiff won't be able to afford to pay you back any of that, well, you're better off actually settling by paying the plaintiff up to $100,000, because you are still better off than if you go to court and win by making the plaintiff lose. So that's a cost trap that defendants get caught in. So they come to mediation looking for a way out of being in a position of having spent $100,000 to defend themselves, but not getting any of that back. So those I outline in the article are the sort of cost trap which parties use mediation to escape. Mediation, as I said, is driven by people wanting to mitigate risk, but that doesn't explain why mediation works. It explains what gets you in the door, but doesn't explain what results in agreement. That is the role of the second central mechanism that I've identified about why mediation works. And that is this: it's what I call the end game of mediation. Every mediation, I say, will end in a situation where, say, at 4 o'clock in the afternoon, after a long and exhausting day of mediation, the defendant makes an offer to the plaintiff, says, look, that's it, that's the final offer, that's all the money that's on the table, there is no more, take it or leave it. So the plaintiff knows, after a long day in which all the alternatives and the possibilities and the strengths and weaknesses have been exhausted and explored, that this is the situation. So the plaintiff then has a choice between two things. The first thing is the defendant's last best offer, money on the table. It's a certainty. It's payable probably within 7 days, maybe 14 days, but it's almost like money on the table. But it's a certainty. It's a reality. It's there for the taking. But almost inevitably, it's much less than the plaintiff had hoped to get. It may not even be enough to pay the plaintiff's legal costs. It may not be enough to repay the loan the plaintiff took out to pay the legal costs of the proceedings. So it's a certainty, but almost inevitably, it's a very unattractive certainty. So choice one is what I call the unattractive certainty. The money on the table is there, it's there for the taking, but it's not enough. It's a certainty, but it's unattractive. It's what I call the unattractive certainty. What's the other choice? The other choice is, well, you don't take the defendant's offer. You decide, no, I'm going to reject it. I'm going to end the mediation. I'm going to go to court. You ask your lawyer, well, what will be the result of that? And your lawyer will say something like, well, you've got a good case, and if you win, you'll get a lot more money than the defendant is offering. But all litigation is uncertain. I can't give you a guarantee you're going to win. So you know a number of things. You know you may win the case. You know if you win the case, you may get a lot more money if the defendant can pay it than the defendant is offering today. On the other hand, it'll take a lot of time. It'll be emotionally exhausting. It'll take a lot more money in legal fees. And if you lose, because you can't rule out losing, you'll have to pay not only your legal fees, but the defendant's legal fees, and that may bankrupt you, or if you're a company, it may put you into insolvency. So the second choice is an uncertainty. It's a matter of uncertainties, which may produce a very attractive result, but may not. And I call that the attractive uncertainty. So you have a choice. You have to make a choice at the end of a mediation. There's no avoiding the choice. The choice is between the unattractive certainty and the attractive uncertainty. Those are the only options on the table. There's no way of avoiding making the choice. If you walk out of the room, that means you opted for the attractive uncertainty. If you take the money on the table, that means you've opted for the unattractive certainty. If you say, well, let's adjourn the mediation and start again tomorrow or next week or next month or next year, that's simply postponing the choice. Inevitably, you have to make the choice as a party to the mediation. And what happens, what I've seen dozens of times, both as mediator and counsel for a party to mediation, is that the party always goes to the unattractive certainty. Because at the end of the day, we as humans are risk averse. We give them that choice between certainty, even though not a very attractive one, and out there in the future, attractive but uncertain choice. Because we're risk averse, most of the time, most of us will opt for the unattractive certainty. That means you accept the defendant's best offer through gritted teeth, you sign on the dotted line, mediation is over, the parties go home equally unhappy, but the dispute has been resolved. That's my view based on 30 years of mediating of why mediation works. I've yet to find anyone in the published literature who's put this forward, but that just, I think, shows how unhelpful a lot of the published literature on mediation is. So I'm running about out of time. I only have one more thing to say, which is, what are the implications of all this? Well, one of the implications of all this is that if you're a lawyer who's representing a client at mediation, your most important job is to explain to your client what I've just told you, what's going to happen. What's going to happen at the end of the mediation when it's 4:30 and everyone's tired and everyone wants to go home, everyone wants to find a way to resolve the dispute. You're going to have to explain to your client that he or she or it is going to be in the position of making this, what I call a terrible choice between an unattractive certainty and an attractive uncertainty. Forewarned is forearmed. I will say to my client, the party that knows this pressure is going to come will be in a better position to resist the pressure than a party that doesn't know they're going to be put under this pressure. And so I say to my students, if you're going to be a lawyer at a client, representing a client in a mediation, your number one job is to explain to your client what's going to happen in the last half hour of the mediation and the pressures that will be brought to bear on him, her, or it. If you don't do that, your client's at the mercy of the pressure that's going to be brought on them, and you haven't done your job properly as a lawyer representing that client at that mediation. Folks, that's all I want to say. Be interested in any comments or posts about what I've said, because I'm always interested in expanding my knowledge of mediation and why it works and how it works. And now I'll turn you over to Vikram and thank him for the opportunity to speak to you all.
Thank you, Robert. I think obviously we can go on listening to you, all your various articles. There are so many interesting ones. Obviously, we can't take everything here, but in general, I mean, there would be some questions I would have more on the fact of the law regarding mediation in Australia. A little bit on that, if you can tell us.
I didn't get the question.
The law relating to mediation in Australia. Can you just talk a little bit about the law?
Well, the law about mediation is pretty straightforward in Australia now. Most, if not all, courts have the power to require parties to engage in mediation, whether they want to or not, at any stage of the proceedings, and possibly on more than one occasion. That's accepted. The law of contract now provides that an agreement to mediate will be enforced by the court if it is sufficiently clear terms, and arguably you can get specific performance, a degree of specific performance of an agreement to mediate. When you're in mediation, it's pretty clear that the law relating to misrepresentation applies to you. The fact that you're conducting the mediation in private doesn't mean that you can exclude the law of misrepresentation. There have been cases where misrepresentations made in the course of a mediation, which induced the other party to settle, have been challenged. So you can't exclude the law of actionable misrepresentation. And as I mentioned, the ethical obligations on lawyers representing clients at mediation also can't be excluded. As you'd expect, they still apply just as strongly as when you appear in court. So really, that's a way of saying that mediation is mainstream, that it's not a little thing sitting out on its own with its unique rules, that the general law of contract and misrepresentation, the laws of professional obligations all apply in mediations just as they do outside mediations. That's my snappy summary of the law of mediation in Australia.
But what about, I mean, when we talk about private mediation, is that developing to an extent that you can be only a mediator?
There are two classes of people in Australia who just do mediation. There are some lawyers, solicitors and barristers who have limited their practice to mediation. There aren't many of those, but there is a growing class of retired judges who cease being judges and practice as mediators. I have mixed feelings about that because A, they're hard to compete with as someone who's not been a judge, but secondly, because it's hard for ex-judges to mediate in a facilitative way, because for say 20 years or so they've been sitting on the bench giving judgments, and the more quickly and decisively they judgments, the more highly they're regarded. But as we all know, in mediation, if you want to be a facilitative mediator, the thing you're trying to avoid doing is making judgments or looking as though you favor one party's position over the other. You're trying to be strictly neutral and impartial and not give a hint to what's going on in your mind. Inevitably, we all form judgments, but the hard part about being a facilitative mediator is not letting on what those judgments are. It's much harder for ex-judges to do that because they're used to giving judgments and people are used to seeing them giving judgments. So those are the class of people who are private mediators in Australia.
Perfect. So Robert, let me just introduce you to Anna. Anna is in the US and of course, well-known mediator and a lawyer there. Robert is a senior counsel in Australia. So,
hi Anna.
Hello.
Where are you in the US?
San Diego, California.
Right.
Robert is in Sydney.
Oh, that's very nice.
And he writes very interesting articles. You must read them. I'll put a link in the post that I put out also. Very interesting. He has this totally different thought on everything. He spoke about some here, but there's lots more. So Robert, what we'll do is Anna's session starts. So we'll just take it there. So I'll thank you very much for the presentation. And obviously, like I said, there's so much more to hear from you. So
No problem.
Yep. Thanks a lot.
I'll send you a link to the articles and to the case I described.
Perfect. Thanks a lot. So what I'll do is I'll just stop the